Good afternoon. My name is Bob Famiglio. My call sign is K3RF. I have the pleasure of serving as your Atlantic Division Director. I've been, I guess, almost 2 years now. And I was, for many years before that, Vice Director for Atlantic. And I'm a life member at ARRL since 1967 when I was a kid, and I got licensed and I joined. I'm also been a volunteer counsel along with my other two colleagues here. I was, I think, one of the first to join, and I actually tried my first antenna case before PRB1 in 1985. My first case was in 1983, and I lost it because there was no law in our favor, and 35 feet means 35 feet, no matter whether you have 10 acres or not. Now, a little about me. I think I told you, life member. I'm an engineering graduate. I also practice law. I think I stood in the wrong line after graduating, and I ended up going to law school. It's a long story. I'm in private practice in the Philadelphia area for 46 years, and I have done a lot of antenna cases, not as much as Fred. I am one of his disciples. He turns pink when I say that, red, but it's true. I'm admitted to practice in Pennsylvania, New Jersey, Florida, D.C., and the United States Patent and Trademark Office. It's a separate exam. I've taken a lot of bar exams, and I have a business and technology law practice. And as I said, my first case was in '83. The longest case I ever had was 4 years. In fact, Fred and I got to practice together on the appeals that followed a long 5 nights hearing I had with 15 hours of hearing time. It's for an antenna tower, 500 pages of transcript, 100 trial exhibits, and that was only the beginning. It went from 2014, I have that in here, and we exhausted all our state and federal remedies by 2017. So I've been down the road and I've been beaten up. We've won some too. I'm going to tell you, a lot of lawyers will tell you what they think you ought to do. I'm going to tell you today what you should not do if you want to apply for an antenna permit. Not talking about HOAs, although some of this may apply, and we can answer questions afterwards, specific questions. But the things you should not do when you go to apply on your own for a tower permit. How many people here have done that in their life? Applied for, oh, okay, we got more than a few. That's probably why you're here, right? Well, you may have had mixed success. You may have been successful yourself. You may have done it with or without a lawyer. But the things you don't do, and this is from experience, because a lot of hams, lawyers are expensive. As a volunteer counsel, I tend to talk with hams for free on the phone. Maybe some of you have over the years talked with me, and I tend to do that. And on occasion, I have done some pro bono. I'll show up and help you at the zoning hearing. It's hard to do these days with a law practice, and I'm still practicing full time. But don't assume that you have no zoning restrictions. There are hams that do that, especially if they're out in a rural area. You'd be surprised. I say, oh, I've got 11 acres, and I don't really have any neighbors except cows and some horses, and I'm going to put up a 60-foot tower. Can't bother anybody. There are no zoning restrictions. That's usually not true. Don't assume that you don't need a building permit. This is also popular. We get into these kinds of problems. They get authority because of the zoning, but they don't get a building permit. Most places, most states, will require some type of permit for it to build. Once you're authorized to put that structure, you've got to show them what you're doing so it doesn't fall down and hurt somebody. Don't assume that you can build if you get a permit. We'll talk about that in a minute because that seems kind of strange, doesn't it? Don't assume that you can build to the height granted. And another reason for that, and I'll give you some anecdotal evidence, some examples of things that I've dealt with. And some hams got themselves in real trouble after starting thinking they were doing the right thing. You can avoid this. Pardon me. And don't go to any zoning hearing and wing it. I can't tell you how many hams do that. Say, look, I'm just going to go. I'm not going to spend money for a lawyer. And I do understand that, by the way. And if you're equipped, if you buy Fred's book, you might have a chance. But don't just go in there and figure that if I mess up, I'll just get a lawyer and we'll try again. In many jurisdictions, there's some roadblocks to doing that. Stated another way, do it right the first time, or it's going to take you a long time to do it correctly later. Now, do not assume you have no zoning restrictions. Every piece of land has some zoning restrictions, even if you live out in the wonderful country, where you have 10 or 20 acres. Do not automatically assume that the town or state zoning officer is correct in any assessment. How many times have I gotten calls, and Fred probably, and Dale, where the guy told me it was all right. He said, it's like a silo. You can put up 60 foot or 150 foot because you're out in the sticks, or it's okay, you can put up a 60-foot tower. A lot of times they're well-meaning, but a lot of times they're clueless. Many times they're not, but you need to get things in writing. And I don't mean a text on your phone. You're good to go, Joe. No, don't do that. Many jurisdictions have a little more formal, if you're in the burbs and they have a little more formalities and things like that. They have an application. Some of you have been through that. They want to see, assuming that the zoning says you can put up a tower, and that they have a lot of state laws allow you over and above the PRB1 that we had. Will say you can put up 60 feet. As long as it's otherwise has some standards and it's safe and it complies with the building code. And that's why you need a separate building permit that a lot of hams forget about. Take the time to be knowledgeable about the local code regarding restrictions. Local officials sometimes have no experience with antennas, ham antennas particularly, because we have mostly some interesting special rules that we can take advantage of. But local zoning officials anymore seem to only know cell phone towers under what we call wireless communications facilities. And they'll say, you can't do that. You got to, and I've seen this, Fred and Dale probably have too. The zoning officer said, no antennas, you got to go put that in an industrial part of the zoning or business zoning. And you have to go through all the types of showing of need for a wireless communications facility. We don't fall under that. Zoning officials think we do. Many do. You have to educate them politely. Do not assume you have a place, you can place antennas above the height granted. What the hell do I mean by that? Well, most height restrictions include limited exceptions for amateur radio operators that accept those, have a maximum height. Now, here's my point, to the tip of the antenna or the support structure and the antenna, not the top of the tower. I have had a number of hams call me, said, I got a permit for 60 foot. Okay, that's reasonable. Had a 1 acre lot and 60-foot house bracket with some guys. And then they want me to, they say I violated the approval. I went and looked at it. The tower was 60 feet, but he had 10-foot mast, and above on the top of the mast, he had a 12-foot fiberglass diamond, tri-band FM antenna. So do the math. That's a lot more than 60 feet. What doesn't count? It's the antenna. This is just the tower. That's not, unless the zoning or the rules that apply to your application say that it's limited to the antenna structure and that all appurtenances, fancy legal word for antennas, are the things that you attach to it. Unless it exempts those, many do not, unless Fred helped write it for some towns, or maybe Dale did, or other ham lawyers that know something about something. You go to the very tip, and this includes just multi-band, or a single boom Yagi antenna that has support structures. The real big ones that you're hankering to put up have extends above the mast or the bracket, the thrust bracket, a good 5-8 feet, and you've got the support structure for the large boom. That violates the height. They'll make you take it down, and they will come and look, and no, they don't have to climb it. One ham say, well, go ahead and climb that. It's 60 feet. I dare you to. No, they just take us. They know what to do. They got a laser, or they have a transit, and they can tell. I have one experience with that about 25 years ago in a county outside of Philadelphia. So you have to see and check whether those structures are separately defined. Masts and supports above the tower have to be taken into account. Don't do that. That's a common mistake, and it will ruin your day, because it doesn't seem like a big deal, but they'll make you take it down. And how do you do that? You got to take 10-foot section down, put another thrust bracket, do the whole thing. So what did 43 years of doing volunteer counsel teach me? Hams don't care to do their homework. They don't bother to consult lawyers before applying for a building permit. Again, not selling lawyers because it can cost more to hire a lawyer. I mean, you can use that money, buy a nice new 7300 or something, right? But and we understand that. But do your homework. If you have a situation that you're not clear on, consult a lawyer. But you want to make sure that you get a zoning lawyer, or at least a lawyer that's knowledgeable. There are no do-overs. If you take nothing from this brief discussion but this, it's important. Because hams do this all the time. They go in and they try to wing it, and they know people on the board, and they're all neighbors and everything, and they get turned down because the rules, they don't get a variance because variants aren't provided for just because you want something. It has to fit within the zoning code. And they say, all right, well, I'm going to do it over. I'm going to get a lawyer this time. Darn it, go spend some money, and I'll show them that. It's never a slam dunk situation. What happens is that once you make a record, once you have a decision, you make a record, any documents that you apply in that hearing, and testimony typically at a zoning hearing board will be taken down with a court reporter. That makes people nervous because they don't realize that. There's a transcript. And you are stuck, sort of, with what you say and the documents that you put up. Wanting a big antenna is never enough. Know the elements of your case. What do you have to show? Go in, and most hams will tell me that I told them that we're good at emergency communications and we do all this great stuff. And that's all true. But that's not the reason they're going to make a finding that you comply with any exceptions that are allowed under that code. Do your homework. Very few details in the zoning application can be adjusted once filed. I see that all the time. So, well, I'll change it next time. Well, you've got to be right the first time. If you need expert reports, and I'm not going to go into that because this is going to just a short presentation, get them lined up ahead of time because it takes you a long time to find out what you need. Yeah, a showing of need sometimes in some jurisdictions, if you want to comply with what's left of PRB1 or other state exceptions for hams. And some of the state exceptions are actually better than what our federal law now provides for. Oh, be ready for the clown cars. Alternative facts will usually be allowed in zoning appeal hearings. Neighbors will come in, they will argue. This is one at a hearing about 10 years ago, the opponents, and that's the one that took 5 nights, 15 hours of hearing, brought in a QST article from 1989. This is a real article that written by an MD, had no footnotes. I don't know why we allowed that to be published, but he said ham radio transformers and the power supplies and stuff could cause cancer. They got that into evidence. You can't make this stuff up. It was 1989. I have it as it's defendant's trial, or the what was it? I was the applicant. Protestants trial exhibit. Send me an email, k3rf@arrl.net, and I'll send it to you. It's a PDF, and you can't make this stuff up. Oh, the arguments about RF radiation are popular. All the 5G stuff, I don't get that too much in Pennsylvania, but out on the West Coast, it's a really big thing. Now, ham radio. It's anything that's RF now. Forget the science. You're going to hurt your neighbors if you transmit. And of course, they're using their cell phones and their Wi-Fi, all the time. Hearing boards are important. Don't just wing it. As I said, judges of the facts will not be confused by them. Those people on the hearing board that will hear you either for an appeal of the zoning denial or a building permit denial or both, they're not. They're not confused by the facts. They'll make them up if they need to. If you need to appeal, you'll be stuck with the record. We talked about that. Put your best foot forward because you're not going to get a do-over. And if you can get a do-over, it's going to cost you a lot more and take a lot more time to get de novo facts. You have to change the application. You have to do something different. Depends on the jurisdiction. This is my favorite. And I know that those of you who have been through this have been through this. Don't expect rational outcomes all the time. The world is flat to some low information administrative panels. Now, that's some anecdotal evidence here. Hams, these are actual decisions in an important, very formal, highly appealed case. Mr. DiPolo. The findings of fact, the formal findings by the board that hams can use the internet to communicate and therefore do not need antennas. as a finding of fact. It's like a jury finding. Hams can use satellites because the opponents brought people in and articles, and hams use satellites now. Why do you need those big antennas? It's an actual board finding. They made a finding, and I don't know how they got to this, but the 16-foot height antenna is usable for microwave, and there's 100-foot trees on the property. This particular guy had 4 acres on top of a hill, and it was a dirt road, and unpaved road, and he owned the road. You know, yeah. Do it right the first time. We've talked about that. Make your case up front. Once you get a chance to make a record, your life will be more difficult with a bad record, even with a good lawyer later. You come out of this happens a lot. They come out of a zoning hearing where they got their butt handed to them. I'm going to get a lawyer. I'm going to appeal. Show them. Yeah, you can, but you're stuck with a bad record in many jurisdictions. You don't get a de novo, that means start from scratch, ability to try it more formally. You only get one chance. Now, even with a good lawyer, if you have to appeal, it's better to appeal with a good record, even if you had a not so good lawyer later. I mean, a good record you're stuck with. I mean, and a bad record, really, you're stuck with. Not every ham can hire a lawyer, so, okay, do what you can. Not every zoning lawyer knows antenna laws. We know this, especially antenna laws applicable to amateur radio operators. Let me tell you what I do and some other volunteer counsel do with phone calls. We don't handle your case for free. I mean, I've done that, but my time on the phone, I can only speak for myself. Some volunteer counsel can't do this. But I will talk with you on the phone, and I spend an hour or two, anybody that's ever called me over the many years. But what I do that's more valuable, I guess he's pointing to somebody, but what I do that's valuable is also say, find a good zoning lawyer where you are. I get calls from all over. And I will talk with him or her for free. But if they're a zoning lawyer, they'll understand what the exceptions are. I can point them in the right place. I can answer questions. And that makes all the difference. If you do nothing else, get Fred's book. Now, he doesn't pay me to say this, but it's on the 3rd edition. But what's remarkable about antenna zoning for hams, his book, is that it's written for both the non-lawyer and the lawyer. And that's hard to do because when you write something for a ham that's non-lawyer, you would think it'd be dumbed down and that lawyers wouldn't find it useful. But in his case, it's written so it's readable by people who are going to do this on their own. And yet, as a lawyer, when I read it, just to see what I've missed, it's also quite good. They have citations, good explanations, and develop in his book. It's long, but it's worth reading. And you read the chapters that you need if you don't have time. But it's good because it will tell you what you need to do and explain why and how best to do it. So, yeah, the disclaimers. I've got to do that. This is a general presentation. And to help you avoid the troubles that we see, and this is true of all zoning law compared to other kinds of law that I deal with. I have a business and technology-oriented legal practice. And it's the same in many states, the general theories. Zoning is one of the most local set of laws that you have. It varies town to town, state to state certainly, county to county. Town to town has their own set of zoning laws. So you've got to know the local law, and you've got to find somebody that knows how to do that. And this discussion isn't going to take place of a focused legal preparation advice from your local counsel. And as I said, just buy Fred's book if you do nothing else. Thank you, and we'll answer questions afterwards, I guess. Okay.